if we won't define religion as what it is, right, the duty to worship the Creator, and so an actual response to God, then it's an open question who we are in fact fighting for expanded religious liberty protections for, right? If atheist groups and secular humanist groups and indeed Satanist groups can take advantage of religious liberty protections, then they are actually using the First Amendment to do irreligious and often anti-religious things. I think that's far from the meaning of the First Amendment, but more importantly, it undercuts the actual virtue of religion, which is a subset of the virtue of justice, right, which is giving God his due. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. We have an interesting group of cases we'll be covering today. We're going to start with oral arguments in a Fifth Circuit case that could have some interesting consequences about the proper definition of religion. Then we'll go to a win for parental rights on the Supreme Court emergency docket in a case called Mirabelli. And then we'll finish with a case in Michigan concerning a religious university's policies around employment. That one's very complicated and convoluted, and we think has some good lessons, especially for our nonprofit users and practitioners about best practices and policies. So a lot to cover. Let's dive into the first case here in the Fifth Circuit. So this case, the district court decided it in, I believe it was July of last year. It's a case called McCutchan versus Nicholson, and it's actually pretty fascinating, especially the legal posture of what's happened. So I'm going to go through a little bit of the background, both because I think it's interesting and because it will be relevant to what's going to be decided now in the Fifth Circuit. So in this case, a secular humanist group is seeking to have its secular celebrants allowed to officiate weddings in Texas. That's a problem because Texas law permits only officers of religious organizations as well as judges to officiate weddings. So the statute lists a couple of kinds of ministers. You can have priests or Christian ministers, rabbis, other ministers of religious organizations, or else judges are the people who can officiate weddings in Texas. This humanist group, which is anti-religious and very explicitly does not believe in God, is not a religious organization by their own definition, but they want to have their celebrants recognized in the same way as religious clergy. So the basic argument defending this law is that non-religious people already have access to wedding ministers. They can be married by a judge. But the argument goes on, and it's, again, the facts and the legal posture are pretty fascinating. So the plaintiff here is there's an individual who's a member of this organization, but there's the secular organization itself, which is devoted to science and the promotion of a secular society. The group here wants to supply secular wedding ministers in Texas. And in a fascinating turn, in the district court, the Texas Attorney General, who was arguing to have this case thrown out, actually argued that the case should be dismissed, not because this discrimination by the statute is permissible under the First Amendment, but because the secular group is a religious group for purposes of the marriage statute and of the First Amendment, and so can already allegedly provide ministers for Texas weddings. Interesting turn of events. The plaintiffs say, we're not religious, but we want to be ministers. Texas AG comes in and says, yes, you already are religious ministers, and so there's no controversy here. The Northern District of Texas dismissed the case and was having none of the AG's argument. It's a really good opinion. This decision, frankly, from the district court warmed my heart. This is an issue I've been writing about for years in my personal capacity, and the Texas District Court opinion, not to be proud about it, but basically follows the work that I've been doing. They didn't quote me, unfortunately, but the history of the case law and where it's gone and what the court held here is basically an outline of the article I wrote on the original meaning of religion in National Affairs last year. So fun to read that and see what I think I was once a pretty lone voice on, but actually start to get treated by courts and by advocates of religious liberty. So what the court says here is traditionally and correctly, the courts have defined religion as one's view of his relation to his creator or the duty that he owes to his creator. We see this in James Madison. We see this in the 19th century case law, though there's not much of it, like U.S. versus Reynolds, Davis v. Beeson. But then since the mostly 1960s cases around conscientious objection, the famous ones are Torcaso. Well, Torcaso is about an oath of office for a non-religious person. Seeger is a famous conscientious objection case. we've gotten a really confused and non-theistic definition of religion that's been adopted in certain cases. Um, the tests are varying and I think not particularly helpful. They look at philosophies lived and adopted by non-religious people that occupy a similar place in their lives as religion does to religious people, and then holds that that too can be religion for purposes of the First Amendment. It really makes no sense because it's a roundabout definition saying, well, religion can be things that are not religion, but that are like religion in the life of the non-religious believer. We're off the rails there. And interestingly, the district court agrees. They limit the application of cases like Torcaso, and for purposes of a First Amendment challenge like this, they hold to the theistic definition of religion and say if it's not theistic, it's not religion, and you don't get religious liberty protections. Obviously, I'm paraphrasing what is a longer and very good district court opinion, and you should read that. But after the court rejects this reason for dismissing the case, they do dismiss the case against the plaintiffs for lack of standing. So there's that. That's I'm not going to go into that, but basically, the individual plaintiff, the man who is part of this organization, they dismiss for lack of standing, and then the organization claims organizational standing, but the court basically says, well, you don't have an individual plaintiff who has standing, so you lack organizational standing, and so no one has standing here to continue with this suit, and so the district court dismissed. So it was appealed. It's in the Fifth Circuit, and the court recently heard oral argument on the case. I'm not going to go in depth on the oral argument, but just pointing out that Beckett filed an amicus brief, and there were some really good arguments focused not on the standing issues, but primarily on the definition of religious issues. So I guess I'll be brief here, but I'm just pleased to see the definition of religion getting so much attention. I know there are standing issues. I'm hopeful that this case gives attention and gives us an opinion on the merits of the definition of religion question. Like I said, I've been writing about this for years and hoping to find a case that can go up to SCOTUS to maybe fix a coherent definition of religion under the First Amendment. I'm not sure if this is the case to do it, but it was good to see a court willing to actually take this up, especially to see a district court willing to be bold enough to say, no, we have a problem here with religion needing to mean religion for us to have a coherent First Amendment. And I'll also say that I think there are some pretty serious implications for religious liberty if we don't take this question seriously. Right? There's been so much good work done over the last decade, especially 10 or 15 years, to expand religious liberty protections. But I've always worried, and that's why I worked on this question, that if we won't define religion as what it is, right? The duty to worship the creator. And so an actual response to God, then it's an open question who we are in fact fighting for expanded religious liberty protections for, right? If atheist groups and secular humanist groups and indeed Satanist groups can take advantage of religious liberty protections, then they are actually using the First Amendment to do irreligious and often anti-religious things. I think that's far from the meaning of the First Amendment, but more importantly, it undercuts the actual virtue of religion, which is a subset of the virtue of justice, right? Which is giving God his due. So if we can use religion to, in fact, do things that are anti-religious, I'm just worried that it's creating exceptions and expanded protections for groups that were never meant to be covered under the First Amendment. And I'll end with this great quote from Amanda Sauls, who's an attorney at Beckett. She argued the arguments in the amicus brief that Beckett filed at the Fifth Circuit. She's also a Napa Legal GCP Fellowship alumna. So she said in the press release, some people treat football like a religion, but that doesn't mean Dallas Cowboys fans get constitutional protections as if they were churches or synagogues. Very well said. Religion can't mean everything or anything that people hold seriously, or else it doesn't really mean anything. And we're not actually protecting religion. We're just protecting whatever things people believe deeply in. And that's not what religious liberty protections are meant to do.
Absolutely. Frank, thank you for your great explanation. I know you've done a lot of great and really important work in this area in defining religion under the First Amendment. So I just want to add a little bit of color and some history on what the founders likely understood religion to be. And I'd have to give fair credit to Philip Munoz, who's done a lot of great research on this, especially in his book, Religious Liberty in the American Founding. So, eight of eight states drafted founding era declarations of rights, and all of them included some notion of religious liberty. And in those notions of religious liberty, they included a brief definition of religion, and they all read pretty similarly. Virginia says that religion is, quote, the duty which we owe to our Creator. Delaware's, quote, all men have a natural and unalienable right to worship Almighty God. Pennsylvania, North Carolina, New Hampshire, and Vermont all use identical language. New Jersey's original constitution says that, quote, no person shall ever within this colony be deprived of the inestimable privilege of worshiping Almighty God in a manner agreeable to the dictates of his own conscience. So if you go back and read almost really any early protection of religious liberty, whether it's a state constitution, early legislation, declarations of rights, you can see that it was broadly understood as the right to worship God. It was very clearly theistic, and it was very clearly in positive light of a deist as well.
Yeah, and I would just say before we move on that it's important to note that this is the early American founding. There were some heterodox religious beliefs, right? Like it was founded on groups that you had, Anabaptists coming protesting the Anglican Church, Church of England. You had you had Mormons who were kind of on the peripheries of whether they would be provided religious exercise rights. It was an interesting time. So I think it's really important to say that religion under the First Amendment doesn't just mean um, Orthodox Christianity. It does clearly have a broader definition. I think the duty to worship the Creator is going to probably involve any bona fide monotheistic religion. It's going to be broader than most Christians would maybe even be comfortable with, but it can't be limitless. That's the only point. I think it's a pretty mild, modest point being made here that it clearly covers a wide swath of religious beliefs, but it has to have an end, and that end is things that are not religion. That it shouldn't be particularly controversial, but here we are.
So that will move on to our second update. In Mirabelli v. Bonta, a case on the Supreme Court's emergency docket, the court recently ruled against California's parental exclusion policy. So the facts are probably familiar to a lot of the listeners of this podcast. A public school district in California required its staff to, quote, socially transition kids that self-identify as, having gender dysphoria, or say that I'm a different gender than my sex is. Socially transition, for anyone unfamiliar with the term, is kind of the common phrase for treating a boy like a girl by pronouns and names and vice versa. So no medical intervention yet, but kind of when you interact with this person, acting as if they're a member of the other sex. So beyond that, staff were also told to conceal socially, quote unquote, transitioning these kids from the child's parents unless the child gives them permission. So this is the parental exclusion policy. You treat boys like girls and girls like boys, and you lie to parents about it. Now, this lawsuit began when a few teachers subject to this policy sued the school district, and the district said it was basically required by the California AG's interpretation of state law to have the policy. So that's how Bonta's name got on this case. So as this case proceeded, several other parents and teachers joined the suit in a class action, and some of the stories were pretty tragic. One set of parents, referred to as the Pose for anonymity, have a daughter who's been going by a boy's name and has been asking people to call her him at school in 7th grade. And throughout the year, the teachers followed the girl's request and didn't tell her parents. And this wasn't just like a passive, I'm not going to send a parent an email out of the blue. They had face-to-face time with these parents and just refused to bring up the subject. They had parent-teacher conferences and never gave any indication that this girl was asking to be a boy in class. Now, this girl, the Poe's daughter, very tragically attempted suicide at the start of 8th grade. Thank God she's still alive. But only then did the parents find out that she was asking people to call her a boy. And even then, she only found out from the doctor. The school never actually told her. And a few months later, she was again put in the hospital for being at risk of self-harm. So once she finished middle school, this girl started at a new public school in 9th grade, but it's still a California public school, and she's still being treated the same way. So she's a girl still asking the school to treat her as a boy, and the school's doing it and not telling the parents. There's lots of other similar stories in this case. There's one where a set of parents actually confronted the principal and said, "We think our kid is asking to go by like the opposite name and opposite pronouns. Is that true?" The principal just kind of leans back and says, "Well, our policy says we can't talk to parents without the child's consent." So even in direct confrontation with principals, they have to fall back to this policy where they say, "Oh, we're going to do what we want, and we're not allowed to tell you about it." So the federal trial court initially ruled in favor of the parents and teachers. They issued an injunction against the policy. And then on appeal, the Ninth Circuit placed a stay on the injunction, putting the policy back into effect while the litigation continued. So these parents appealed to the Supreme Court on the emergency docket, and recently the Supreme Court vacated the Ninth Circuit stay and ruled that the parental exclusion policy likely violates the First and 14th Amendments. Now, the legal analysis here is actually pretty important, both in this case and in a lot of other similar ones. As I mentioned earlier, this was a class action from several parents and teachers, and they fell into two broad categories. One argued from a religious perspective on the First Amendment grounds. The second argued from just a non religious, more secular argument under the 14th Amendment, and the court ruled in favor of both. So the First Amendment analysis, like I said, this will actually be really important for lower courts because here in Mirabelli, the majority relied on Mahmoud v. Taylor, which was, for anyone unfamiliar, you probably have heard of it, but if you've forgotten the case name, it's the decision last term that the Maryland public schools can't force sexually explicit and LGBTQ materials like Pride Puppy on kids as young as 4 without having any parental notification or providing parents the option to opt their kids out of those classes. So here in Mirabelli, the court clarified that Mahmoud, and also Yoder, an older case that is kind of given new life since Mahmoud, but it ruled that these precedents establish that the government can't interfere with the rights of parents to guide the religious development of their children without violating the First Amendment. Here, as applied, the parental exclusion policy made it impossible for the parents to raise their kids in the faith. Right? Part of their religious belief is that God made sex and he made it immutable and made us in his image and likeness. And schools with the policies, then unconstitutionally, in the court's words, cut out the primary protectors of children's best interests, their parents. So it's really important that the court relied on Mahmoud in this case because in doing so, it corrected the Ninth and Sixth Circuit's misinterpretations of Mahmoud. So the Ninth Circuit, which heard this on appeal, tried to cabin Mahmoud as a narrow decision focused on, quote, uniquely coercive curricular requirements. So they basically tried to say that, sure, Mahmoud set this idea that the government can't replace parents' religious beliefs, but that only kind of applied in this particular circumstance. It was just in curriculum. It was particularly coercive. Here, the court clarified that no, this is much broader than just books in a class, right? It says that the opinion says that, quote, indeed, the intrusion on parents' free exercise rights here, unconsented facilitation of a child gender transition, is greater than the introduction of LGBT storybooks we considered sufficient to trigger strict scrutiny in Mahmoud. So in its First Amendment analysis in this case, Supreme Court made clear to lower courts that Mahmoud wasn't just about extremism in English classes. It was about the protection that the protection that the First Amendment offers to religious parents when the government tries to replace their beliefs with the state's preferred ideology. The second kind of set of parents and teachers, like I said, was under the 14th Amendment. And there's a little bit more controversy that I'll kind of give a very brief background on, but then kind of cut to what the court ruled here. So our listeners are likely familiar with the controversy surrounding substantive due process. Substantive due process essentially holds that the 14th Amendment, which prevents the states from, quote, depriving any person of life, liberty, or property without due process of law, also protects fundamental unenumerated rights, so ones that aren't written in the Constitution, as long as they've been recognized in America's history and tradition. The controversy around SDP arises because it, at least as some people argue, that it lets judges legislate from the bench. Nowhere in the 14th Amendment is there anything about substance of laws. It's all about just procedure. And under SDP, judges can just kind of unilaterally declare that something is a right. That's how we got Roe v. Wade. Essentially, the court there held that substantive due process protects the quote-unquote right to an abortion. That's a bigger discussion for another day, but I just kind of wanted to give some background on what's going on with the 14th Amendment here. So as applied here in Mirabelli, past Supreme Court decisions have found that the right to direct the upbringing of your kids is protected by a substantive due process. That's under Pierce v. Society of Sisters in Meyer v. Nebraska back from the 1920s. And then this substantive due process right to direct the education and upbringing of your kids includes being involved with discussions affecting their mental health. Here, gender dysphoria is a serious mental health condition that impacts a child. The court said that thus the parental exclusion policies take parents out of the picture when their kids struggle with this at school. So kind of putting these two First and 14th Amendment tracks together, the court ultimately ruled that public schools can't cut parents out of a deeply vulnerable and unstable part of their children's lives without violating free exercise, or at least as we currently understand it, due process. So this wasn't a final ruling. It was only a vacatur of a stay. So there are several similar cases currently pending cert and working through lower courts. But the fact is that millions of kids are in public school districts that have these types of policies. And Mirabelli signals to judges deciding those cases how they should rule. Lastly, I'll close with really what I believe is the biggest impact that Mirabelli is going to have. And fortunately, here, the majority affirm the fact that gender dysphoria, so feeling like you're a member of the opposite sex, is a mental condition that, when a child has it, necessitates medical and parental involvement. The opinion acknowledges that basically stopping these policies, quote, promotes child safety by guaranteeing fit parents a role in some of the most consequential decisions in their children's lives. So the legal analysis matters here, especially with how the First Amendment will impact other courts based on the Mahmoud decision. But at the end of the day, the issue is whether kids can have their parents by their side when they're suffering and need guidance. Mirabelli's most important effect is ensuring that vulnerable, often depressed or anxious kids are not abandoned to the state and that parents have the right to be involved in their child's upbringing.
Yeah, I'll just say a couple of quick things. That's a sufficient summary of all of this and where we are. I'll just say, first of all, point well taken on the substantive due process question. Right, this is anybody who's read Justice Thomas concurrence on any substantive due process case, or who's just has an interest in this. I think there is a doctrinal problem with substantive due process, right? Because I mean, just read the clause, right? No, you can't deny life, liberty, or property without due process of law, which means that you can, in fact, deny life, liberty, or property. You just need to have due process, notice, fair hearing, so on. I think it's pretty clear by the plain reading of the due process clause that it's not meant to give substantive rights, because I mean, substantive rights and procedural rights are actually like opposites. So I think it's kind of ironic. I think it's interesting if you read the opinion. I think it's by Justice Barrett here, where they're ruling on the substantive due process part, and they're kind of embarrassed by it. Like they're not quite saying that substantive due process is a fiction, but they're going to use it anyway because that's the precedent. But they're basically saying that. So I think everybody kind of knows this who's serious about like the original meaning of the Constitution and what due process properly is. But that aside, it is important to note that we're not making stuff up here, right? Right. Whether we find unenumerated fundamental rights in the Privileges and Immunities Clause, which is where Justice Thomas wants to find them, whether there's an argument that the Ninth Amendment, which says that, right, the existence of enumerated rights explicit in the Constitution do not deny the existence of other unenumerated rights. Wherever you find it, it's clear that there are rights that American citizens have that are not enumerated. They don't have to be listed in the Constitution, or else you just don't have them, right? That's not our legal system. We have a thick tradition of rights, not all of which are enumerated in the Constitution, and parental rights, like the right to raise and direct the upbringing of your child without state interference, is clearly among those, whatever doctrine of the Constitution or law you find them in. Um, I'll also point out just one quick note, and then we can move on. Is that I think it's interesting and kind of funny how I guess some members of the Supreme Court view themselves and the Supreme Court. There's something in the dissent from, I believe this is Justice Kagan, who basically says, this was rushed. This came to us through the emergency docket. Clearly, the majority in this decision knew what they wanted and they were just going to do it. And we didn't have the time to properly review the record and so on and so forth. I think this is a misunderstanding of what the court is. I think this is a view that makes the Supreme Court look like this big, slow, ponderous, philosophical group that, if we weigh in on a case, it's going to be slow, steady. We need, all the time for all of our clerks to read every opinion. And sure, I mean, when you're setting precedent, that's the ideal, and that's the way the Supreme Court handles its regular docket, right? They hear a certain amount of cases on appeal every term, and they write the decisions and release them very slowly after a lot of deliberation. That's great. But the thing is, the Supreme Court is the highest court in the land. It is still a court. It's not an academic institution, and they're going to get emergencies, right? Like in this case, when you have the district court and then the circuit court trampling on religious practice and substantive rights of parents in pretty severe and severe ways that need immediate rectification. That's what the Supreme Court exists for, right? Like this is not something that you could say, well, let's take this on the normal docket, give us months to brief it and hear oral argument, then we'll decide. So, no, in the meantime, we have a clear pattern of these school districts continuously not telling parents about their kids' problems, even when they're disastrous, right? I mean, the example you gave, Joseph, really highlights the need for emergency relief here. And this girl um, was, secretly, quote unquote, socially transitioned, was suicidal. Like clearly there are mental health issues going on. Parents find out about it. She goes to a different school and they're still doing it. So obviously nothing short of court intervention at this level and in a quick fashion is necessary to prevent harm to kids. So I think it's a good reminder that the Supreme Court is in fact a court and they're going to have to hear emergency decisions and you might not get all of the briefs and the time to deliberate that you'd like. But I mean, quite frankly, that's not the prime issue. The prime issue is the court has a job to do, and here it involves a short timeline. So that is what it is.
Yeah, absolutely. I think the dissent completely misunderstands what an emergency is. I mean, it's clearly irreparable harm, and it's a very serious and time-sensitive issue. And then I just want to add one other comment on some of the breakdown with the substantive due process issue here. Justice Thomas would have, the per curiam opinion notes that Thomas would have voted to take the case in full and get to it onto its traditional docket, maybe to make his case again against substantive due process. And the concurrence that you mentioned that Barrett wrote was joined by Kavanaugh and Roberts. And they're not the most vocal critics of SDP, but they still recognize that there is some problem. And even the dissent said, yeah, we get it that the due process clause said nothing about parental rights, but that's what it's protected under. So there's this clear recognition that there is still this debate going on in the courts of whether or not substantive due process is long term a viable legal theory.
Yeah, it's just going to be a hard. I think eventually you'll get a growing groundswell who wants to take the words and the meaning of the law seriously enough to say this is not the right place to find fundamental rights. The problem is then you have to very carefully unwind and rewind, as it were, like over a century of decisions about fundamental rights and where they come from. So that is a case for another day. But the case for today, before we close up, let's finish up in the Michigan court system. This one is fascinating. I think the facts are very confused, but I wanted to just briefly highlight the case so we can use this as a shill for the kind of work we do at Napa Legal because it's really important to get your policies right when you're a religious organization. So here we have a Protestant university that is affiliated with a denominational church called Calvin University. There was a professor there who was terminated in 2022 after he officiated the wedding, purported wedding, of a woman who identified as a man. This is further complicated by the fact that this was no ordinary quote unquote transgender wedding, but the woman who identified as a man was actually the professor's coworker. She went to the school, she or worked at the school, and so here we are. He officiates at this purported wedding, and he is fired for doing so. So the former professor sets up the lawsuit by saying the university violated Michigan's Elliott Larson Civil Rights Act, which mandates that the university is not allowed to fire a professor for association with someone who has quote unquote transitioned. The school claims, I think rightly, that they fall under the ministerial exception. Right, they require all their faculty to uphold the statements of faith, both in their professional capacity and in their public life. Um, but one of the issues in this case is that while the university defines marriage as between one man and one woman, the religious group that founded the school, the denomination, has changed over time. They allow members who have same sex attraction or have taken transition hormones to be part of their ministry and to be open about it. So here we have kind of a convoluted track record of what the school and the denomination's policies on these sex and marriage issues actually are. So the professor claims that before he officiated here, he discussed this case with fellow coworkers, with members of the church prior to officiating, and everyone he talked to allegedly said this should be no issue. But he was still terminated after he officiated at this purported wedding. Sorry that I keep saying purported, but I do think it's important to be clear that when two biological women want to get married, there is indeed not a wedding just based on nature. So anyway, this means that there might be an issue on whether something is a sincerely held belief or not for the university. It's not clear. There's another interesting argument in the case that I'm not going to go into in detail, but the professor actually claims associational discrimination. This will be Michigan's first case of impression on this issue. Professor claims that while the ministerial exception may protect them in some instances, it does not protect the school when it refers to who the professor associates with as a reason for termination. I think the associational discrimination argument will likely fail because, first of all, the ministerial exception is pretty expansive if the professor is indeed a minister. And second of all, because they are pretty clearly not firing him for who he associates with. They're firing him for an act that allegedly is at odds with the religious beliefs and decisions of the university. But that being said, I want to focus on the confusion around the church and school and their policies, because again, the record's confused. It seems that the university has some policies um, on sex and marriage. It also seems that the university's policies may be in conflict with the denominational policies of the church, which it seems are more liberal on sex and marriage issues. But it also seems that there wasn't a clear written policy about officiating weddings that are not between one biological man and one biological woman. Um, so I won't go into the fact pattern. I'll be interested to see what happens here because this is basically a showdown between a non-discrimination law at the state level and the ministerial exception. My guess is that the ministerial exception will prevail, if not at the Michigan Supreme Court. This may be a U.S. Supreme Court case. We've been kind of itching for more ministerial exception church autonomy cases. This one could be it. The Michigan Supreme Court doesn't have a great track record on religious liberty. Um, but the legal litigation scenario aside, I just want to end with this. This is a case for compliance and corporate governance best practices that we advocate for at Napa Legal, right? If a religious organization requires certain religious beliefs and practices from all of its employees, ministers and non ministers, they should be crystal clear. They need to be crystal clear. They should be in the employment handbook. They should be in organizational policies. They should be in mission statements, and they need to be detailed, not just we uphold the truth about human sexuality as found in the Bible or whatever. Needs to be like we affirm that marriage can only be between one man and one woman, and no employee, especially a minister, can be involved in a wedding or a purported wedding that is between anyone other than one man and one woman in accord with the teachings of the church. It needs to be clear. Otherwise, you're going to get a fight like this. Like, well, I didn't know. I didn't know that this was actually against the policy of the organization, especially because this person, this woman identifying as a man, works at the organization, is public about it. So I don't think the organization had too big of a problem with her witness against their supposed Christian faith. Point being, you need to be consistent in the policies and statements, but also in application, right? If the organization let me okay, let me make this final point. Um, we often have this problem of religious organizations being afraid maybe to be too overtly religious on hot button issues. So they say things like, well, we believe marriage is between one man and one woman. We believe what the church teaches, but they're not specific or they don't want to go all the way or they want to make some accommodations. But really, that's a problem. If you want to maximize your religious protections under the First Amendment, under church autonomy and ministerial exception, your best bet is to be very clear. We are a religious organization. We believe A, B, and C. We require X, Y, and Z of all of our employees. That is integral to our mission as a religious organization. That will serve you much better than having vague or incomplete religious statements in your employment policies. And if you are vague and unclear, then you end up getting situations like this, where instead of having a clean cut, this is what we believe, it was violated, and we have a ministerial exception right to terminate this employee, it's not very clear what your organization holds up as its religious beliefs and practices because you didn't make them clear in your documents. So this is just a case to sign up for our all access resources, go through the employment module, which we're updating this month, actually. But we have a sample employment handbook for religious organizations, schools in particular. It's very important that you maximize your protection by stating very clearly who your organization is, what it does, what it believes, and what it requires of its employees. Less specificity is not good. And in fact, like we see here, it's problematic.
Yeah, absolutely. Like you said, Frank, this is one of those cases where corporate best practice really matters. If Calvin University in this case had a clear statement of faith or clear employment handbooks, the fired professor's case would be a lot harder to assert. And one other thing I want to bring up is that we had discussed the Union Gospel Mission case out of the Ninth Circuit a few weeks ago. While it's only binding in the Ninth Circuit, it does signal a bit where church autonomy could head. And there, Judge Bumate wrote that the church autonomy doctrine protects the rights of religious organizations to hire or fire non ministers for sincerely held religious reasons. For anyone kind of wants to unpack a little bit more of church autonomy and ministerial exception, Frank just did a great episode with Rachel Morrison from the Ethics and Public Policy Center last week. So definitely encourage you to listen to that. Um, But I do agree with you, Frank, that the ministerial exception argument here is probably pretty strong. But just to play this out a little bit, let's say here the exception argument fails. If other circuits adopt a similar understanding of church autonomy as the Ninth Circuit, a religious organization could protect itself in a lawsuit like this by showing clear evidence of religious motivation. So here, if again, if the Ninth Circuit applies it, if the Ninth Circuit's application gets interpreted the same way in other circuits and courts, and if the ministerial exception argument fails, if Calvin University had a statement of faith saying that marriage is between one man and one woman and that biological sex is immutable, it could easily make the point that the professor is fired for sincerely held religious reasons and is therefore protected by church autonomy. So it is a little bit of an aside because there's a couple ifs there. But if the Ninth Circuit's understanding of church autonomy gets applied elsewhere, it'll be all the more important for religious organizations to be clear in what they believe.
Yeah, no, I think that's a really important point, the greater church autonomy question, because this is very relevant, right? Let's say that even if Calvin University doesn't have the most strict, specific applications, right? If the statement of faith says marriage is between one man and one woman, biological sex is immutable, but they're maybe undermining that by hiring people who identify as trans or being looking the other way when there are people in purported same sex marriages working there or ministering there. Okay, but church autonomy is still relevant here because then if then the argument becomes, well, you're undermining your witness because you're saying you require this behavior and this belief, but then you're allowing this, and then it becomes an entangled religious question, right? So the court has to go in and say, okay, what what interferes with the school's religious witness? What doesn't? Does it count if like can they allow an employee to work there who identifies as trans, but not for a minister to hire that like now you're getting really into the thick of religious questions. The court is being forced to take the place of the religious body and saying what does our religious witness require? And that's a thorny thing for organizations or for courts rather to get involved with. So the takeaways, I think you're right, Joseph. Church autonomy can definitely be in play here. But that aside, it would be a much stronger situation for the university to go into if they had been very specific in the behavior and the practices that they require of their employees in their policies in the first place. All right. And with that, well, thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it. If you like the podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening. If you want to support our work financially or find out what we're up to, you can visit our website at napalegalinstitute.org. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you so much for joining us, and God bless you all.